The chair thanks the chairman. The chair recognizes himself for 5 minutes for the purposes of questioning our witness. Chairman Leibowitz, during the housing boom, the FTC had clear jurisdiction over many of the worst predatory lenders with the most objectionable practices. But the commissioner arguably didn't do much to address any of these activities. As a matter of fact, it was the states that successfully brought actions against lenders, such as Countrywide and AmeriQuest, for their abusive lending practices in the subprime mortgage market. In the second panel, former Maine Attorney General Jim Turney will talk about these and other issues a little more. But to begin with, I want to ask a simple question to you. What happened at the FTC? Why did the FTC not take aggressive actions against mortgage lenders in the earlier part of this decade?
Well, Mr. Chairman, I would say sometimes the simple questions are the most difficult ones to answer, but let me try to respond. First of all, I think, as you know, we are a tiny agency by Washington standards. We have 270 attorneys doing consumer protection, and as Mr. Radonovich and others mentioned, we cover the entire waterfront of the economy with a few exceptions like common carriers. So we have to, and we spend a lot of time doing things like stopping fraud, going after spyware, as you know, because we've talked about that together. Having said that, I think we did a pretty good job. We brought 70 cases in the last 5 years. We've gotten in the last 10 years $465 million in consumer redress, and that's just in this area of financial services alone. Could we have done more? Yeah, I think we could have done more. Will we do more in the future? Yes. And do we need to work with the state attorneys general? Yes, and we do it all the time. We're part of several regional task forces. The director of our Atlanta office, our Southeastern Regional Office, has actually set up a task force with the state AGs, and they're going after predatory lending. But yes, we can do more. I've been exchanging phone calls with Attorney General Holder about resurrecting something called the Executive Working Group, which involved the Federal Trade Commission, the state AGs, and the Justice Department. And it was something that was used in the 1990s and the 1980s to sort of coordinate efforts. I think we're going to resurrect that. And I think that would be, you can ask Attorney General Tierney, but I believe that that will be something that's welcomed by all the state AGs, and it'll allow us to help coordinate even more.
You asked for new authorities for the FTC, such as additional rulemaking authority, the ability to seek civil penalties, and possibly additional authority over banks and other depository institutions. But there are critics, and some of them are on this panel, or on the next panel rather, and they argue that the Commission hasn't been aggressively using the authority it already has. My question is, given the FTC's record over the past 8 years, why should we give this authority to you now? How can you assure us that you will use these authorities to aggressively protect America's consumers?
Well, I think, you raise a very fair question, but I'd say this. We are hamstrung, speaking for myself, we are hamstrung by the Magnuson-Moss rulemaking process. When you have passed laws like CAN-SPAM, Gramm-Leach-Bliley, FACTA, you've given us APA rulemaking authority so that we can do rules more quickly. But on a Mag-Moss rule, and I think Mr. Radonovich raised the rationale for making rulemaking, and Congressman Stearns too, for making rulemaking more complicated under Mag-Moss. It's a legitimate argument. But what we have found is that sometimes it takes 6 or 8 years to do rulemakings. And when it takes 6 or 8 years to do rulemakings, it is impossible to do a rulemaking in a timely manner to stop or to respond to a crisis. So, for example, 2 years ago, we did a sweep of internet advertising for mortgages, and we found facially deceptive ads in over 200 different companies on the internet. And the commissioners had discussions about what should we do about this. Well, we ended up bringing some cases against the worst malefactors. We wrote letters to everybody. Some people cleaned up their work. But we couldn't do a rulemaking because under MAGMA's rules, by the time we started or finished the rulemaking, we knew that Congress would legislate in this area as they should. And so if we can have some relief from MAGMA's, I think we can be more effective in helping consumers. And it's a legitimate debate. You know, I think when you reach our reauthorization, which I know you want to do this year, we'll have a discussion about the broader broader MAGMA's rulemaking relief and finding malefactors. But again, you can be much more effective if you have finding authority. You can be, which we don't have for violations of Section 5. You can be much more effective if you can do some sort of streamlined rulemaking authority too.
My time is up, but I want to inform the members of the subcommittee, if the chairman will indulge us, we want to go through a second round of questionings. The chair now recognizes the gentleman from California for 5 minutes, Mr. Radonovich.
Thank you, Mr. Chairman, and welcome, Mr. Leibowitz, to the subcommittee. Congratulations on your recent appointment.
Thank you so much.
I did want to ask a couple questions. This first one, I'm going to ask about 5 questions to the subject matter about why would you like the FTC to have an APA notice and comment rulemaking to define unfair deceptive acts for financial services? Why isn't the current Section 5 authority sufficient?
Well, I'd say 2 things. First of all, in the Omnibus Act, we have finding authority for the rules that the Fed issued under the FTC Act and rulemaking authority. We're going to use that to go after deceptive and unfair mortgage servicing and in some other areas. Why do we want expanded rulemaking authority? Because we think when you write rules, you can set standards for an entire industry. And here, where you have many, many actors, it's better to try to set standards. And also where we've seen a pattern in practice of bad behavior by many companies, not all, but many. And so we think it would be helpful. It would make us a more effective agency here.
Do you have thoughts on what kind of rules you'd like to propose for the activities that are not already covered under existing statutes?
We do. I think debt negotiation would be one area. We'd want to work with the committee in thinking about other areas, but yes, we do, and we can get back to you with some more thoughts on that.
What about the what would be the most prevalent consumer fraud violations in financial services that you think the FTC should be pursuing that it currently can't?
Well, I mean, I guess I'd say this. We found a fair amount of fraud in the entire life cycle of the mortgage instrument. And when you have an economic downturn as severe as the one that we're in now, I think there's more of an incentive to see more of this. So, you know, we're in the mortgage area. We now have that rulemaking authority. It was given to us in the omnibus. We think that's going to be helpful. We think we're going to be able to find malefactors and write good rules. But I think, and we have deployed more resources. We've really doubled our resources in the last 2 years to go after predatory financial practices. Having said that, there's just no shortage of bad acts that we can look at in this area. Most companies, of course, do the right thing, but there are a lot of people who've just been ripping off consumers, and the cases that we brought today sort of attest to that.
Right, yeah. And I'll get onto those cases that you brought in just a second. One more quick question, though. Why can't the Commission use your existing authority to propose rules defining unfair acts and practices for financial services? Why can't you use what you have now?
Well, again, we could do it, but if they're not if it's not under APA rulemaking, notice and comment rulemaking, then it takes us literally years to do the rulemaking. I don't think that serves the American people well. I don't think it effectuates what you want us to effectuate on this committee.
Okay, thanks. Now, with regard to the cases that you mentioned, that you've listed and presented a very good record of the cases that the Commission has brought under a multitude of laws that you already have to enforce, but unscrupulous actors continue to violate the law. Will more laws or rules reduce that fraud?
They can't. I think. Look, and we'll have some of this discussion going forward when you look at our reauthorization. I think growing the agency would be something that would be enormously important. We have about 1,100 employees. We do antitrust and consumer protection. In 1980, we had 1,800 employees, and the population of the United States was a third smaller than it is now. So part of it is more resources, but I also think part of it is the ability to have rulemaking authority.
And you've got to balance this idea of dealing with the bad actors, and there may be more of them out there, you know, during this financial crisis or not. I don't know how you measure how many bad actors are out there, but you know, the other side of over-enforcement is higher compliance costs. And where do you find the balance to where you're regulating so much that you know, we have higher cost of goods out there as a result of it?
Well, Congressman, you're right. I mean, we have to strike the right balance, and reasonable people can disagree about exactly where that balance should be. But look, we've brought 68 cases in the last 5 years in the financial services area against malefactors. We have no fining authority. 47 attorneys general, I believe, have fining authority to go after people who violate the law. And so fining authority is something you get for violating a rule, and that would make us that would be a very important tool in our arsenal. And by the way, when you've passed pieces of legislation like Can-SPAM, which came out of this committee, you've given us that fining authority, at least for specific matters. So it's a discussion we want to have with you going forward, but that would be one thing that would make us more effective, I think.
All right. Thank you for your answers, and thank you, Mr. Chairman. Yield back.
The chair, thanks to the gentleman. The chair now recognizes the gentlelady from California, Ms. Matsui, for 5 minutes for questioning.
Chairman Leibowitz, as I mentioned in my opening statement, the issue of loan modification scams is a growing problem, particularly in California, where we have the highest numbers of homes going into foreclosure. We hear individuals and companies advertising on radio and television with a simple message that they can lower your mortgage payment and stop your foreclosure. And many of these people are calling themselves foreclosure consultants, or in some cases, acting like they were government agencies like HUD. Right. They make guarantees and promises to homeowners seeking help to save their homes. But this help usually comes with a price tag in the form of an advance fee between $1,500 up to $9,000. That being said, I'd like to hear what the FTC is doing to crack down on these fraudulent loan modification scams. In your written testimony, you announced 2 new cases targeting mortgage foreclosure rescue scams, bringing a total to 8 such cases. Is enforcement the right approach to ending this type of fraud? You initiated 8 cases. Will those cases serve as a deterrent to other scammers? And are there other steps that the FTC can take to end these practices?
Right. Well, it's a great question, and we do think that these. And by the way, I should mention that we are also members of the Sacramento Task Force, and many task forces in your districts around the country. Well, I do think that the cases against Hope Now and New Hope, which are 2 entities that are claiming to be affiliated with the Hope Now Alliance, are ones that will be helpful as a deterrent. But we also think that rulemaking authority and fining authority will make our ability to deter more effective. And again, we want to do rules because they're needed in the mortgage servicing area, in the mortgage modification and rescue area, and going after rescue scams. So we like to be able to use the whole arsenal. We've been given some authority in the Omnibus Appropriations Act that will be helpful. We're looking for more authority from this committee, and we want to move forward with that if the committee believes it's appropriate.
Okay, some examples of fraudulent schemes are these, as we mentioned, the advance fee scams, where consumers are charged for services and never rendered, and in exchange for this fee, it's up from $1,500 to $9,000. Homeowners are promised guarantees to save their homes. In some cases, consumers usually pay these fees with a credit card, which should make it easier to track the payment and help the consumer recoup their money. What is the government doing to help recoup these advance fees to make consumers whole again? And is there a mechanism in place to help consumers recoup their advance fees?
Sure. I mean, when we bring these cases, and by the way, the Hope Now case is a case that involved an advance fee of $1,000 to $1,500. My understanding is that when consumers got no help whatsoever or very little assistance, when they asked for their money back, it was gone. So when we bring these cases, we try to ask for disgorgement of profits. We try to get redress to consumers. In the case we brought against Bear Stearns' subsidiary, EMC, we got 86,000 redress checks issued. But it's tough because sometimes these assets dissipate, and sometimes it's hard to determine, not in these cases, but in other cases, which loans were fraudulently made or which advertisements were deceptive and which ones weren't. And that's why a penalty authority will be very helpful to us if we can get it.
Well, do you think Congress should ban these advance fees?
I would want to come back. I would want to think about that. We've certainly seen experience. We've certainly had experience with these advance fee scams including advance fee credit card scams, that make us think that certainly the practices of a lot of companies should be prohibited. But as for advance fees generally in the financial services area, I would want to think about that because there may be some value when legitimate companies are doing some things with advance fees.
So would you think then that the FTC should declare its view that it's an unfair practice to charge an advance fee for services that do nothing to save a home?
Well, I would certainly think that we could look at that in the context of our rulemaking, and some states, I believe, do ban advance fees in the financial services area. So it's something we can take a look at.
Okay.
And I think we probably should in the context of any rulemaking authority we've been given in the omnibus or that you give us additionally.
Okay. Well, thank you very much, and I see my time is up. Thank you.
Thank you. The chair now recognizes the gentleman from Nebraska, Mr. Lee Terry.
Thank you, Mr. Chairman. I appreciate this. The gentlelady brings up, I think, several good points, and I think really gets to the heart of the matter, and that's if we're going to streamline rules, the procedures for the rules, we want to make sure that it's going to be effective in protecting consumers and that you will be able to use the FTC's authorities. But the argument here about advance fees begs the question of who is ultimately going to be able to decide what is deceptive and what is not. Sometimes it's obvious where you can put 100 people together and they'll say that practice is deceptive. There are other things like maybe advanced fees that some people will say are deceptive or that are wrong, but they're not deceptive. And so how are we going to split those hairs if you're coming to us and asking us to streamline the rules or the procedures to make your rulemaking? Who should have the authority in there to determine which specific practice is deceptive or not deceptive?
Well, I think that's right. And then some practices may be deceptive as practiced by some companies, whereas other companies may do them in a legitimate way. I'd only point this out.
That's why it's really hard.
Right. It's a good question. And whether we're bringing cases or whether we are enforcing rules that we've promulgated, we have to go before a federal judge. So there is that mechanism as a check and balance against any excesses of the FTC. But I don't believe that anybody has suggested, at least in the last 25 years, that we have engaged in any excesses at our agency. I think people think that we're a pretty good agency, and we try to do the right things with our limited resources and leverage those resources.
In specific about streamlining the rule process so you can be more nimble.
Right.
Do you have specifics for us, or is that just kind of a general statement that would be helpful for you?
Well, I think it's both, in the sense that if we have more agile rulemaking, something closer to APA rulemaking, we can respond more quickly. I do think that we're going to, use the APA rulemaking authority given to us in the Omnibus Act, to address foreclosure rescue scams where we know there are very, very serious problems, mortgage modification, where we know there are problems. We know that both because we've testified to it and others have, and also because of the Bear Stearns case where we saw lots of embedded fees that consumers just didn't know about and were being hit with.
Yeah, those get to be fairly obvious.
And let me just add.
But go ahead.
My staff pointed out that advance fees are prohibited under CROA, We prohibit them in the telemarketing sales rules, which is an FTC rule. In some instances, not in every area, but in some instances, there's really sort of help cleaned up bad practices that harm consumers.
All right. And those were developed within your own rules? You decided that in those instances,
The telemarketing
advanced
sales
fees-
rules. The telemarketing sales rules were promulgated by us, pursuant to legislation enacted by Congress in the early 1990s, I believe.
Right. But for those specific instances with the specifics of advance fees, that was something that you did within the FTC by rulemaking.
Yes, that's exactly right.
And that's the point that I'm getting to. I guess there's two sides of the coin that we can look at here. And one is we can say, criticize the FTC over the last 8 years for not being aggressive enough. 8 years from now, are we going to look back at the FTC when we streamline your rules and say you were overly aggressive and without specific congressional approval defining general practices as deceptive practices, thereby freezing trade?
Look, it's a fair question, but I think in these times of, where we have seen so much harm to consumers by deceptive acts and practices, you might want to, given that we're an agency that has a track record for being aggressive but balanced, you might want to err on the side of giving us more authority. Believe me, in the 1960s and 70s, Congress was always able to pare us back when they thought we were going a little bit too far. But again, in areas like debt collection, in-house debt collection, where we've seen problems, including in the Bear Stearns case, and debt negotiation, those would be areas not covered by the omnibus where we think we could do.
In my last 14 seconds, I'm just very curious. In the last several years, you said in the financial services area, you've brought 40 or 60?
68 cases.
68 complaints. Generally, what were those? What's the major area specifically?
It's really a combination of different areas. It's 7 mortgage advertising, 5 payday loan cases, 6 payday loan cases, a couple of fair lending cases, mortgage servicing cases, 9 foreclosure rescue scam cases, and 12 credit counseling cases, and 11 debt collection cases. Those are and 17 credit repair cases as well. So it's a combination of different areas, all mostly within our financial services group, and then we've had our regions. We have 7 regions regional offices around the country doing more of this, doing more in this area, because it's a high priority for us.
Gentleman's time is up. The chair now recognizes the vice chair of the subcommittee, Ms. Schakowsky, for the 5 minutes for testimony.
Thank you. Chairman Leibowitz, since 2001, state attorneys general have been active, often aggressively pursuing the bad actors in the field of consumer credit. They took the lead on cases like Household Finance, AmeriQuest, Countrywide, and uncovered extensive abusive practices, inflated appraisals, fabricated income statements, misrepresentations to borrowers, illegal and deceptive fees and rates. Was the FTC approached to participate in these activities?
Some of those cases took place before I came to the commission. I believe in AmeriDebt, which is a terrific case done by the state AGs. We approached them about whether they needed our help, because we're always happy to help with cases, and we work a lot with state AGs. And I think that they were, I think that they demurred on that they were.
Okay, but
ahead.
My understanding is that in fact the commission has often opted not to participate. In fact, a former Attorney General, James Tierney, who will be sitting on our second panel, in his testimony, he states that the past 8 years have been a time of limited cooperation between the FTC and state attorneys general with respect to enforcing consumer protection in the areas of consumer credit and debt. So would you agree with this assessment?
Well, I would say this. I can't speak for the first I can't speak for the first 4 years, from 2000 to 2004. I wasn't at the commission. From 2005 through now, we have been working fairly often with the states. We are involved in regional task forces. But look, we can certainly step it up, and we certainly will. And one of the things that I'm very heartened about is our very positive conversations with Attorney General Holder about resurrecting the executive working group, which was very active in the 1990s, and sort of was flailing in the last 8 years. It's a way for us to help coordinate with the Justice Department and with state AGs through regular meetings our consumer protection activities. So I think that will be a big plus.
Wonderful.
And we want to do more going forward.
Let me talk about a different area. Under Section 18 of the FTC Act, whenever the Commission promulgates a rule on unfair or deceptive acts or practices dealing with consumer credit matters, the Federal Reserve and other banking agencies are required to promulgate a similar rule for depository institutions or explain why such a rule is unnecessary. So were we to give the FTC speedier APA rulemaking under Section 18 of the FTC Act, would this not ameliorate, at least somewhat, the lack of functional regulatory parity because of the reciprocal requirements under Section 18, whereby banking agencies have to consider the FTC's lead?
Well, Congresswoman, it might very well be helpful, but I think what your question touches on, and I know you know this, is the sort of incredible balkanization, right? Consumers don't know whether consumers don't care whether they got a mortgage from a bank or whether it came from a non-bank mortgage company, right? If it's deceptive, if it's, a subprime loan or a non-subprime loan with hidden fees that they don't know about, it's hurting them. So we have this sort of balkanization of authority here. There are 3 or 4 different banking entities or banking agencies that have some jurisdiction over the 60% of the mortgages that are issued by banks. We have the jurisdiction over the others, and I think that's why Elizabeth Warren and a professor at Harvard and a variety of folks on the Hill are thinking, that it may be time to have one single entity that protects consumers from predatory financial instruments. And certainly I know people on this committee are thinking about that, and I want to make sure that from our perspective, we're a consumer protection agency.
So you could do banks as well, is what you're saying?
We could do banks as well. I would say with this qualification, the banking agencies, they're mostly concerned with safety and soundness. We don't do safety and soundness, so we're not those kinds of bank regulators. But if you want an entity to do consumer protection for consumers who have financial instruments, we can do that really, really well.
Okay, let me ask the final thing.
Sure.
There was a colloquy on the Senate floor that clarified the authority that is this trigger under Section 18 was not under Section 18 and only applied to non-banks. Do you see this, if it goes forward, as a missed opportunity?
Well, do I personally see it as a missed opportunity? I certainly think Congress needs to look at the notion of a single entity, whether it's housed in the FTC or whether it's a new one, to protect consumers from predatory financial instruments, deceptive and unfair ones. I see this as actually an opportunity for us because the language in the Omnibus Appropriations Act gives us rulemaking throughout the entire life cycle of a mortgage, only, of course, for non-bank issued mortgages, but that's a real opportunity to do rulemaking, and after we do rulemaking, to actually be able to have standards, you get those from rules, and to find malefactors who fall below those standards. So I see your point, and and we are very supportive of Congress having a discussion about creating an entity to protect consumers here. But I also think we've been struggling for this legislation for quite some time. It's going to be helpful to us. Thank you.
The chair now recognizes the gentlelady from Ohio, Ms. Sutton, for 5 minutes.
Thank you so much, and thank you, Mr. Chairman, for your commitment to look after the entire life cycle of credit. There are so many questions that I have. I'm going to probably need to follow up after the course of this hearing to try and unravel exactly what is going on out there, because I can tell you that my constituents are feeling the effects of all of this confusion that it's kind of confusing for anyone who's watching this hearing to figure out who has authority over what and who has the responsibility to protect them, let alone, know where to turn. So in the last line of questioning from my distinguished colleague, Representative Schakowsky, we're talking about the new opportunity you have within limits for rulemaking. But if I was to ask you this question, it sounds to me like you have limited opportunity for rulemaking that will provide some people protection, but there's a whole nother category of people out there who may be suffering from the very same thing and the same practices over which you have no ability to help them. Is that correct?
That is correct.
Okay. Let me go on record as saying I don't think that makes any sense.
No, that makes a lot of sense. And again, and I mean, going back to Ms. Schakowsky's questions, one of the other things that's sort of peculiar about this rulemaking is that the Fed can promulgate rules under the FTC Act by notice and comment rulemaking, APA rulemaking, the simple rulemaking that we can then enforce for our over non-bank mortgage company, over non-bank issued mortgages. But if we want to do that rulemaking right now, it would have to be under Magnuson-Moss, and it would never get done because contested rulemakings under Magnuson-Moss just don't get done. So we're glad that they promulgated these rules. We're glad we can enforce them. We think those rules are going to be helpful in curbing bad advertising and things like liar's loans. But it is like trying to, even for the commission, and all of the commissioners are very, very hardworking. It is like running through a rabbit warren to try to figure out how these laws interact and regulations interact with each other.
Well, again, I appreciate that very much because it seems like we should be able to inject some more sense into the process and into this puzzle. In your testimony on page 8, you talked about suing a credit card marketing company. Obviously, you can reach the credit card marketing company. Can you tell me what exactly is a credit card marketing company?
Well, we can't reach, as you know, we can't reach bank-issued credit cards, which is about, I think someone said 75%. I think it's now probably up to about 95%. So a credit card marketing company is simply a non-bank affiliate or surrogate that markets the credit card. And what we found with some of our advanced fee cases is they'll say, you can have a credit card, give us $500, and then when you give them $500, some of it's taken away by fees, by prohibitive monthly costs, or you can only use the credit card to buy from their catalog. So those are some of the types of cases we brought. And then we had a major case involving a company called CompuCredit, which we brought jointly with the banking agencies, where they had and it was a credit card company that actually targeted subprime borrowers, people who couldn't otherwise get credit cards. So that's a sort of laudatory at some level. But the credit card limit was $300, and the first month had $185 in fees, which weren't accurately disclosed, we allege. And we had a settlement for $115 million for consumers just the end of last year. That was very, very important for us. Okay, so the question that I have, though, is if a bank is engaging in the exact same activity, can you do anything about it? We could run across the hall to the banking agencies where they're testifying and tell them they should take a look at it. We can go talk to them, but we can't do anything about it. That's my point, and that's my concern. Okay. Mr. Chairman, I'll hold my questions at this point till the next round.
The chair thanks the gentlelady. The chair now recognizes my friend, the gentleman from Pennsylvania, Mr. Pitts, for 5 minutes.
Thank you, Mr. Chairman. Mr. Lebowitz, as an overwhelming number of mortgage fraud cases began to surface in 2007, the FBI formed a financial crimes task force and has had more cases than it can handle, and these are largely criminal fraud cases. Does the FTC have a role in investigating these cases? If so, would you elaborate?
I want to get back to you on those cases. We do a lot of work with the postal inspectors. We do some work with the FBI, of course. But when we see something that's criminal, we generally refer it to the Justice Department. And if they'll take it, they have, more appropriate sanctions than we do. We, generally can only get redress and disgorgement. And stop the bad conduct. So sometimes we're sort of the fallback entity for going after fraudulent behavior in this area. But I will get back to you on whether we've worked with the FBI task force specifically.
Okay, thank you. The Commission has conducted research on ways to improve mortgage disclosure. If the disclosure documents were simplified in a manner that provided relevant information similar to the prototype disclosure developed by the Commission, would that have prevented any of the fraud that occurred in the home mortgage loan market, in your opinion? Or might fraudsters simply find a way around that simplified uniform disclosure?
Well, I would say this. Fraudsters, can often find a way around even simplified disclosures. And I hope all of you have the draft disclosure form on your desk. If not, we'll make sure we get you copies. But sometimes what's happening is that consumers don't see embedded fees. And what we've done with our sort of disclosure form, it's simple. We've copy tested it. In other words, we've asked consumers to look at this and compare it to the existing HUD, RESPA, TILA forms that they use. And those forms have they're both over-inclusive and under-inclusive. They have too much information, so consumers don't know what to focus on, and they don't focus on some specific aspects of information. So can I say to you that it would prohibit, it would have stopped a specific fraud? I don't think so. But would it have sort of helped some consumers make more informed decisions when they're dealing maybe not with deception but more with unfairness? We think it might have. And even by the way, for consumers, I mean, these forms, or this draft form and others like it, it doesn't just help the consumer who's being ripped off. It helps the consumer who wants to be able to make informed choices, right? You can see, well, here, the fees are going to be more, and here the fees will be, here the fees and the overall cost of the loan will be less. So that's, just helping consumers like all of us make choices from among competitors.
Now, the FTC prohibits both unfair and deceptive practices.
That's correct.
Unfair is defined as any act that causes or is likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves and not outweighed by countervailing benefits to consumers or to competition. Bringing an enforcement action for violation of a deceptive practice is much more common for the FTC. Why are unfair cases brought so infrequently?
Well, I think, you articulated, I think you read directly from the statutory authority we have. It is harder to show unfairness. Unfairness is a sometimes more amorphous term. So when we see, when we're going after your usual, a typical bottom feeder who's ripping off consumers, we just see, it's clear deception. But sometimes, for example, in our spyware cases and in a variety of other cases involving data security and internet-related problems, we'll use our unfairness. We've been using it actually more in the last several years because we think it's important.
Should unfair acts be better defined to provide greater certainty, to make enforcement easier?
I would say certainly if we had a little more leverage in our unfairness standard, we might be able to bring unfairness cases more often. We had a much broader standard in the 1960s and 70s, and then through the late 1970s, and then Congress asked us to modify first of our own volition, and then it put it in a statute, I think, in 1992, our unfairness authority. So this has been a subject of some debate going back and forth about whether we should have a little more flexibility here. We'd love to work with you on this.
Thank you. My time is up. Thank you, Mr. Chairman.
The chair now recognizes the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, an issue came up just now, and I was going to ask you, is there any numbers that the FTC could share with the committee on the number of criminal prosecutions that referred to the Justice Department that actually are taken by the Justice Department? Because I think that's something we'd like to see.
Yeah, we will get you. We will get you that information. We do have Tim Uris, who was the first chairman under President Bush, set up a criminal liaison unit, which we still have, and which takes some of the cases that are clearly of a criminal nature where we started investigations and sends it over to the Justice Department or to certain other prosecutors. So we can get you that information. Some of it, with a caveat that I have to go back and look, some of it may be confidential. And then sometimes, again, as you know from the cases, because you know our agency.
We just need the numbers to see
yeah,
what
we'll get you the numbers.
percentages, and if there are cases that are definitely not controversial, it would be interesting to see what type of cases may not be accepted and what type would be. But
You're right. I can just tell you as a general matter, sometimes the cases don't rise to the level of ones that the Justice Department wants to prosecute, so we do it ourselves.
okay. And you have the ability to do it yourself
Not as a criminal matter, but as a civil matter.
on the civil side.
So, right, to stop ongoing harm.
Our office has been hearing from constituents concerned that the free credit reports that do not list all the information that credit lending entities have access to. Do you know if there is a case, and if so, do you believe consumers should have access to all this information? It seems that consumers should have access to all the credit information available to them. Have you heard of that, or has that been an issue with the FTC?
Yeah, I think we brought a case, I think in 2002 or 2003, before I got to the commission, against freecreditreport.com for, I think I'm summarizing it, but I believe for actually charging fees. There is a place where consumers can go to get a free credit report without entering into a contract, a monthly contract, and I think that's called annual credit report. Annual credit report, and we actually, not to make light of this, but we actually put out a spoof of freecreditreport.com that got picked up by YouTube and by a variety of other media outlets just 2 weeks ago. So this is an area of some concern to us, and I know to consumers we do get complaints on this.
Well, what I was going to say, there may be things that the consumer may not, that's not on that report that's being used for their credit rating.
That's right. Shouldn't be in there.
That was the issue.
Credit reports, credit scores.
Right.
You're talking about credit scores?
Yeah.
Scoring? Yeah. They're included in the free credit report.
And is there any restriction on those, what can be considered to go into your credit score, either by practice or by rule or statute? Yeah, I don't think so. I can't imagine it being. No, so why don't they do it? You know, if you have blue.
Let me, Congressman, let me get back to you on that. It's
Okay.
a legitimate question. I want to give you the right answer.
I know I only have a minute left, but there are many varieties of mortgage foreclosure rescue fraud, but in each case, the perpetrator makes misleading promises the consumer home will be saved from pending foreclosure permanently. Most consumers end up losing their home, however, as well as the money they paid to these scammers. I'm aware the FTC took action in February to sue a company operating one of these scams, and I commend you for that. How widespread is the problem? Does the Commission have the tools and resources to go after a lot of bad actors, not only the one you sued, but it seems like some of it may be even cottage industries that we're seeing in regional areas and not maybe national?
Right. Well, with the entity that we just brought an action against today, that's impersonating HUD, we're having a sort of whack-a-mole problem with them because we found the site. The site was we found the site. The HUD Inspector General took it down. Then it popped up again under a website from Germany, registered in Germany, and then we've taken that site down. So so we have a little long arm problem in terms of asserting our jurisdiction. The other thing is that if we can find these malefactors, which the Omnibus Appropriations Act will let us do, or a provision that Senator Dorgan got into the Omnibus Appropriations Act will let us do, I think that would be very, very helpful. And we will do a rulemaking on foreclosure rescue scams and also deceptive modifications.
If you'd share that with us, even though we're not on, a rider of the appropriations bill and maybe not rise to the need for an authorization, but some of us could help with getting the encouragement of the appropriators to include that.
We would love to work with you. We would love your help.
The chair now recognizes the gentleman from Michigan, Mr. Stupak, for 5 minutes.
Thank you, Mr. Chairman. Chairman Leibowitz, thanks for being here. The Commission, as you've indicated, has authority under Section 18 of the Federal Trade Commission Act, and I understand it's particularly cumbersome. Instead of promulgating rules under the APA, the Commission must go through a far more difficult process known as the Magnuson-Moss Act. So my question is, since you've been chair, has the Commission considered promulgating a rule under the Magnuson-Moss Act? Or have you just sort of disregarded the whole process?
We have a few rules that we're in the process of promulgating outside of this area under Mag-Moss, but they're generally sort of not good government rules, but non-controversial rules, because under Mag-Moss, if you want to promulgate a rule and there's an opposition to that rule, they get to require an independent referee, multiple rounds of submissions, and it takes a really long time.
Do you think Congress should just repeal that?
I would say this. There are probably some legitimate reasons why Congress gave us this cumbersome rulemaking.
Can you give me one reason why they'd give you such a burdensome procedure? If our purpose is to protect the consumer.
Off the top of my head, no.
Yeah.
But I would say this. I certainly think some relief from Magnuson-Moss would be justified. I think the original, look, we're an agency that Congress wanted to give us when they created us in 1914, enormously broad jurisdiction, but fairly limited remedies, right? As opposed to the Justice Department,
right,
where they have to go after more specific crimes and they put people in jail. They have fining authority. And so the rationale for Mag-Moss, I suppose, is that it sort of slows things down because we have such broad jurisdiction. I do think over time what we found is that some relief to Mag-Moss would be helpful in allowing us to have leverage over the bad guys. So, for example, I think 47 attorneys, when you promulgate a rule, you can get a fine for a violation of a rule. Otherwise, when we use our Section 5 authority, you can't do that. And so if we can find malefactors, as 47 attorneys general can do, that would make us more effective in doing what you want us to do, which is protecting consumers from,
But in order to protect consumers, you have to move quicker. I mean, we don't want you to be Justice Department, because you indicate, well, you don't have fines and all that. But isn't really your power is to look for that unfair and deceptive practices and act quickly to cease and desist? Isn't that really the role of the FTC? It seems like Magnuson-Moss is just the opposite. It slows you down, so you cannot be nimble and react to current trends.
That's exactly right. In a controversial rulemaking, in a rulemaking where there's opposition, and many good rulemakings have opposition, we would always look to see what all stakeholders want. Of course we're going to do that, and we're going to do that in the rulemakings that we've gotten in the omnibus appropriations, which will be APA rulemakings.
Right, but that's limited. In the omnibus, your rulemaking authority, that's somewhat limited, is it not?
It's limited.
In the omnibus?
It applies to mortgages,
right,
but not other financial instruments not issued by banks. And of course, it only goes to non-bank issued mortgages. But it's still better than what we had, so we're very grateful for it, and we thank this committee for protecting it in the omnibus.
Well, let me ask you this. Since 2001, the Attorney Generals have been active and very aggressive in pursuing bad actors in the field of consumer credit. They took the lead on cases against Household Finance, AmeriQuest, and Countrywide, and uncovered extensive abusive practices, inflated appraisals, fabricated income statements, misrepresentations to borrowers, and illegal and deceptive fees and rates. Was the FTC approached to participate with the AGs in their...
In some cases we have, and we have participated with them. In some cases, they've done it on their own, and I believe demurred when we've offered help. And then probably there are some cases, again, in hindsight, that we should have been involved in earlier, but they took the lead on that. The Attorneys General have been terrific in, protecting consumers. I don't think we've been slackers at all. I think we've been pretty good. But on a going forward basis, we're going to work more with the Attorneys General.
Okay, so how do you envision working closer relationship between the states as you're now the newly appointed chairmanship? Because I think it's important while the states bring forth, but sometimes they look to you for resources and to help them with these investigations. And I would think that what goes on in one part of the country is probably going on in the other side part of the country, and therefore the FTC should be more involved and should have closer working relationship with the state AGs.
Well, I absolutely agree with that. And of course, we can have. It's easier for us to get remedies that apply across all states, right? And so much of so many of the bad acts in the mortgage industry.
Well, have you reached out to the AGs?
Yes, we have reached out to the AGs, and we've also reached out to the Attorney General. You may not have been here when I talked about this, but we're in the process of trying to resurrect something called the Executive Working Group, which was very active in the 1990s, sort of stopped in the last 8 years. That involves justice, the attorneys general, and the Federal Trade Commission having regular meetings to coordinate activities. That's going to be very, very helpful going forward.
You're right. I didn't hear that earlier testimony. I'm glad to hear it, and urge you to continue that progress. Thanks.
The chair thanks the gentleman. The chair now recognizes himself for 2 minutes of additional questions. Chairman Leibowitz, if this Congress would enhance and expand your regulatory authority, can the Commission set up a separate office to regulate and enforce consumer credit abuses? And if so, would this compromise other core functions of the FTC?
Well, I would say this, as you know, Mr. Chairman, we're a small agency with a pretty large mission, and we have to leverage our resources all the time. So if you give us that authority, and I think a majority of the Commission would be willing to embrace that authority and think we could do good things for consumers, we will need more resources. I don't know that we need to grow to the level we were at in 1980, which was 1,800 FTEs. But I think we would, to discharge, what you don't want us to do is to take people away from spyware cases and other types of fraud cases and then simply move them to the newest, most problematic area and forget about all the other things we do. So I think we need more resources. I do know the appropriations committees are interested in giving us more resources and have given us small plus-ups over the last couple of years because they like what we're doing, but we probably need additional resources on top of that.
I have less than 1 minute, and I just want to ask you another question. I'd like to touch on payday lending. I believe that payday lenders have a role in our economy, but there are far too many abuses. Does the FTC have authority to crack down on payday lending practices such as rollover fees? And is specific statutory language needed to direct the Commission to adequately deal with certain abusive payday lending features?
Well, I would say yes and no. We've brought about a half dozen payday lending cases in the last 5 years. We don't have, obviously, Congress set a cap, I believe, for payday loans outside of military bases at 36% a couple of years ago. We obviously don't have the authority to set a cap, but one thing we found in our payday loan cases is the embedded is that malefactors have sort of embedded fees that consumers don't know about, and so they'll pay off their loan in 2 weeks, but it'll be a day late, and so then there'll be a fee that pops up, and then it's compounded, and then they're sort of in a worse cycle of debt. So we have the authority to do that. I think if you gave us the authority to do rulemakings, we would look at ways to promulgate rules that would require better behavior by a lot of the payday lenders.
The chair recognizes now Mr. Radonovich for 2 minutes for additional questioning.
Thank you, Mr. Chairman. Mr. Leibowitz, you had mentioned that commissioners decided not to initiate a rulemaking on deceptive Internet advertising, and the reason was because Congress would eventually act on the issue, but you would have if you could proceed under the APA. And it sounds like, and I'm going to have a discussion about this, that you're suggesting that the FTC APA rulemaking would obviate the need for a legislative body at all. And adding to that question, I think I would ask, isn't the Magnuson-Moss process intentionally deliberate, similar to the congressional legislative process? I mean, the Founding Fathers set this whole thing up so that legislating was difficult, and should your job be made easier, or should you have to deliberate with us?
Well, we always,
the proper approach to these problems.
All of us think our job should be made easier, but
right.
I don't mean to suggest that we would have obviated the need for congressional legislation if we had been able to do a rulemaking. And I don't mean to say that we wouldn't have stopped, the economic mess that we all know we're in. But I do think we could have cleaned things up more quickly if we had APA rulemaking or something closer to APA rulemaking. But again, these were just discussions among commissioners because we knew that under MAG-MOS rulemaking, it would be very, very hard to do a rule in a timely manner. And that's the problem with MAG-MOS rulemaking. I don't mean to say that there isn't. I don't know if you're here when I was having a conversation with Mr. Stupak. There's a rationale for having us make rules more slowly. And certainly among folks who follow the FTC and have for years and decades, there might have been some excesses, perceived or real, in the 1970s that led to some of the restrictions. For example, the restriction on unfairness that makes, as Mr. Pitts pointed out, makes it difficult for us to bring an unfairness case. But having said that, I think it's worth, and I know you're interested in just discussing this issue further about whether it makes sense to give us some relief from MAG-MOS. Doesn't necessarily mean it has to go all the way over to APA rulemaking, but I do think in some areas, you want us to be able to act more nimbly, more agilely, and more quickly. Maybe not in every area, but in some. And when you've passed new rules or new laws, like CAN-SPAM, you've given us that APA rulemaking, and we have that APA rulemaking in the omnibus for mortgages, for everything in the mortgage life cycle. So, I mean, one thing is watch to see how we do in the mortgage with the rulemaking authority we have. If we do a balanced job, maybe it makes sense to give us just a little bit longer leash.
All right, thank you.
Thank you.
The chair now recognizes the gentlelady from Ohio for 2 minutes.
Thank you, Mr. Chairman. You heard some discussion here about the state attorney generals, and in my opening statement, I talked about some of the actions that we have taken in Ohio. But even after all that we have done, I'm going to read to you the headline of a report from the Housing Research and Advocacy Center that is in Cleveland. The headline reads, "Payday lenders operating in 81 Ohio counties charging up to 680% interest. Lenders avoiding the 28% APR cap passed by legislature and voters," that's at the state level, in 1,020 stores statewide. And just to give you an idea of what's happening here, despite legislation passed in 2008 aimed at lowering interest rates on short-term loans, payday lenders are operating, as the headline reads, in 81 of Ohio's 88 counties, making loans in some cases that carry that extraordinary annual percentage rate, 24 times more the rate that was approved by the legislature for such lending. And they've avoided the 28% cap by using other laws. So they're very crafty, and they're very quick at making the necessary adjustments to continue to reap what they reap. I guess my question just is, what can you do to help, or what can we do to help?
Well, I mean, there's no magic bullet for solving these problems, as I'm sure you know. I was asking my staff about usury laws in different states yesterday as I was preparing for the hearing, and someone pointed out that in Missouri the cap is 2,000%. So you borrow $100, you forget about it, the next year you owe $2,000. Look, one part is working with attorneys general because we have to leverage our limited resources, and that's a part of it. Another part is consumer education. We have a terrific consumer education group, and that's a part of it. I wish I could tell you there's a particular answer to this problem, but there just isn't, and we all have to sort of pull. And by the way, as more people are unemployed, as the economy continues to spiral down, you're going to see more of these problems. You're going to see more people borrowing from payday lenders. Now, Congress made the determination that outside of military bases, payday lenders should be capped at, I think, 36%. I suppose Congress could make the determination that that payday lenders should be capped at 36% and limited in fees. But that's a decision for you to make. I will say this: if you give us more authority to do rulemaking in this area, we'll take a look at payday loans.
With the chair's indulgence, I appreciate that. And thank you for bringing up the issue about loans near military bases. And I'd like to follow up with you about that as well, because I understand that still problems remain, and I would like to talk about how we actually aggressively go after that.
The chair thanks the gentlelady, and the chair thanks the chairman again for the expansive use of his time. We know that you are quite busy, and we certainly thank you for your enlightening commentary to this committee. We do intend to work with you on these and other matters as we proceed. And now we just want to let you know that we appreciate your presence here.
Thank you much, Mr.
And the chair now calls the second panel to the witness table.